Okay, so welcome to our webinar. We are going to be talking about the topic of gray divorce, which Michelle will be getting into here very shortly. My name is Melissa Rosenberg, and I am a mental health provider working alongside Michelle here and supporting this webinar today. I work with a lot of clients in my private therapy practice who are going through relationship transitions, including divorces and separations. I really work hard to provide emotional support for people who are going through these emotionally complex times. I work with both individuals and with couples in providing emotional support during relationship transitions. And so I also work alongside Dellino Law Group to support as many of their clients as possible. And I'm here to try to support this webinar today. So I'm going to turn it over to Michelle to introduce herself and to get us started on our topic. And Michelle, you're muted. Sorry.
A year into this and I still am muting Zoom. Anyway, I'm Michelle Dellino with Dellino Law Group. Thanks for joining us today. We're here to talk about gray divorce, which is actually there are nuances to the legal issues. So we'll cover some of those in general and things to think about and know about. But I want to start out by saying just that in general, what gray divorce is, what that means, because that's a term that is just thrown around. It's not a legal term. It's just a term that's thrown around, and what that really means and who it applies to, and some other things about it before we dive into what to consider. First thing to know is gray divorce was originally coined by someone meaning people with gray hair, which was kind of funny because that could mean nobody. The way that people color their hair, people gray when they're 30, people gray when they're 40, 50, 60, 80, it really depends, but that's kind of where the term came from. It means later in life divorce. That's really what it means. It means people divorcing two different kinds of marriages, either after a long-term marriage, if you've been married, 25 years or 30 years or whatever it may be, and you're later in life and now you're dealing with a divorce, which is something you probably never expected to have to deal with. That's a great divorce. It also can mean divorces later in life that maybe weren't long-term marriages. So second marriages or third marriages, and those marriages dissolving. It could mean those marriages. So and those come with other considerations as well, but they're later in life, so they fall into that category. So it doesn't necessarily always mean long-term divorce. It could mean midterm or short-term divorce. It's just kind of the stage that you're at in life dealing with it. And I did want to say that it's a difficult thing if you've been in a long-term marriage and now you're looking at things dissolving for you. It's probably not something that you expected. A lot of people think that, we've been together a long time, we're kind of past the difficult parts, but there are a variety of things and a variety of reasons that bring about long-term divorce. And it doesn't necessarily mean it's any easier, even though some of the property issues are more simplified actually in long-term divorce. So anyway, there's a host of things to consider. One thing I will say is that I think getting emotional support is important. When you start any family law case, I really break down 3 things you're going to need, and one of them is information. So you're taking a big step here by being here today to listen to what I have to share and to just start, information gathering or fact gathering. So you can do that in a variety of ways. Although that doesn't mean believe everything you read online or on Google, because that is probably not even applicable to your situation. The next thing besides information is support, and that can mean emotional support. It can mean legal support. It can mean financial support. It can mean any number of things. So that's extremely important, and that's no less important than information. And the third thing is gathering resources to deal with your situation. So you may want to plan ahead and gather financials. You may want to gather funds to deal with your divorce and realize what that could mean for you and where you're going to get those funds. So it's really information, support, and then gathering resources so you're prepared. So you're taking a big step by being here today. And Melissa, do you want to say anything about what is helpful to people on the emotional support part before I start diving into some of these topics?
Yeah, definitely. I want to say that one thing that I work with people around in therapy is divorce ambivalence. And that's kind of this term around, maybe there's a lot of people in that phase of thinking about divorce, contemplating divorce, I think, for long stretches of time. And a lot of my clients who I've worked with who ultimately end up in long-term marriages, like Michelle's talking about, have been in kind of an ambivalent state for months, years, and in some cases even decades, where people are, contemplating the end of their marriage, or the separation from their partner for so many years, or such a long period of time. And I just wanted to talk about how ambivalence is such an uncomfortable place to sit. And one of the things that I try to work with clients around is trying to tackle that ambivalence, even for people who are married, not necessarily divorced, but married and contemplating the end of their relationship. I work with people around kind of unpacking what that ambivalence is all about and what it looks like, and trying to determine if there is actually room for relationship repair. And maybe that looks like couples counseling or some other way of repairing the relationship to a healthier state, or helping people kind of unwind that ambivalence and ultimately take the steps that they might fear taking. And so I support people in both ends of that process. But I definitely think that when you're going through a separation or divorce in any state, and certainly in a long-term state, we have to think about the grief and the loss associated with going through divorce, with the kind of compounding major losses that are going on at the same time. It's loss. It's not just loss of your relationship, and that's already so huge, but it might mean, loss of mutual friends. It might mean the extension of your family and loss of some of those other relationships. It might mean loss of kind of your own sense of identity as a spouse, or for what loss of the future that you had in your mind looked like. That's a really big one that people have a hard time wrapping their head around. That the future is going to look different, and the loss of those hopes and dreams that you might have had. Could be some financial loss, could be some time with children or grandchildren that is lost along the way. A lot of different things that could be lost. And so grief is just really, really prevalent for just about anybody that's going through this. And so I really would recommend being sure that you have emotional support in place. Certainly a therapist, I think, is a great place to go, but also making sure that you have your social support network lined up.
Yeah, Melissa mentioning the social support network. That's one thing I was going to talk about too, is that I find that a lot of my clients in long-term marriages or even later in life marriages, because really gray divorce is technically supposed to be people over 50. I choose to think that's not that old, but technically that's what it means. And people later in life generally, a lot of the times, don't want to share with family and friends what's going on. Maybe you're ashamed, or maybe you just feel like I don't want to talk about it anymore, or any number of reasons. But please do, because going through a divorce or separation is a marathon. It's not a sprint. It's not going to be something where the Band-Aid is simply ripped off and it's over. You're going to need people in your life to know. And I'm not saying you have to share every personal detail, but just so people know what you're going through is important. And it can create a lack of awkwardness later as well if one spouse tells your mutual friends, because at that stage in life you often have mutual friends or your adult children or whoever you tell, and then they didn't know. And so it's a good thing to feel like you can tell people what's going on. So let's get started on some of the issues. I do want to talk about why we find that divorces in this category are coming up, and it kind of leads into some of the issues we have to deal with. One of them is that, people postpone divorce a lot. People postpone divorce and they stay in marriages until their children are grown out of the house. That's something that I've seen many times over the last decade, and it's something that's very common. And so what that can mean is nobody's happy in the marriage, but that you've decided we're just going to stay in it until the kids are out of the house. And that, in one hand, takes away some of the issues that you would otherwise have to deal with in a divorce. It sort of narrows the scope. If your children are grown, you're not dealing with parenting issues. There are 4 main issues in a divorce, and I'll hit on those in a few minutes. So postponing them. Empty nesters is like another very common phenomenon that we run into, where people just find after the children leave the home and you're both kind of figuring out who you are at that stage in your life, maybe one of or both of you doesn't see the marriage the same, or it doesn't feel like you've grown in the same directions. And so that can be a reason why. Another really big reason, which we'll also get into, is financial reasons. Sometimes I find that people don't get divorced earlier because they feel like it's just not an option. They feel like, I don't know how we would support 2 households. I don't know what we would do. And sometimes later in life, they find, oh, we're more financially stable now. And I've talked to someone and I understand how my assets can be divided. And I want to do this, whereas financially before I feel like I couldn't. And that kind of is also goes with retirement, which is another big issue to consider in a long-term divorce, and people realizing that retirement goals or people not working anymore can have a total change on the marriage. Whereas your routine for many years was people go out, get up, they go to work, maybe one person helps with the kids, someone else helps with the kids later. You guys have kind of a routine. And when one or both parties retires, it can bring a totally different dimension to the marriage. And it also can be a financial thing. So these are definitely some things to consider and some things to know about. So I'm going to talk about the 4 issues in every divorce and kind of which ones apply in gray divorce and which ones typically don't. So the first issue, which we'll talk about a little more in a few minutes, is division of debts and assets. That applies in every divorce. So every divorce, whether you have kids or not, whether you've been married for 6 months or whether you've been married for 36 years, it doesn't matter. You're going to divide your debts and assets. Another thing I should mention on that note is I do find sometimes people later in life after long-term marriages, one party might not be fully ready to accept the divorce, and maybe somebody decides we'll file a legal separation instead. I just want to say, if you're dividing debts and assets and you choose to file a legal separation, we can talk about that as well later. Legal separation, you still will divide debts and assets. So that applies whether it's a divorce or a legal separation, you'll divide your debts and assets. Let's talk about what that means. Well, in Washington, you may know, if you're here, you're information gathering, so you may know that we're a community property state. And that means that, what is community property? Every asset and every debt too acquired during the marriage, during that whole period, is deemed to be community, which means both parties have an interest. Name on title, it doesn't matter at all. You could have one, let's say one party worked for 30 years and put all their money, put a ton of money into a 401k, and they think at the end, well, hey, my name's on that. I'm the one that I went to work and that's mine. That's actually not true. It's because both parties have an interest in it. Same with wages. If you put money into a savings account, one party might be doing that, the other party might be doing that. Doesn't matter. Everyone has an interest in wages earned during a marriage. Almost everything that is acquired, whether it's real estate, real property, personal property items, those are all presumed to be community if they're acquired during the marriage. The things that are not community during the marriage, and this is a big one that comes up in gray divorces, are inheritances, because maybe you're a little older and your parents are passing on or are making estate plans and you come into inheritances. And if you have, and you do, inheritances are presumed separate property in Washington. So that means the assumption is that it will remain separate property unless you do something to change that. And there's a couple different ways you can change inheritance to make it community property. So you can talk more about that as well. But in general, inheritances are separate property. So you've got this community, you've got division of debts and assets, you got to divide it. So how do you divide it? And that is definitely a gray divorce issue, because how you divide debts and assets in a long-term marriage is different than how you would divide them in a short-term marriage or a mid-term marriage even. And if you were in a gray divorce situation and it's not a long-term marriage, you're still looking at dividing assets later in life. So that's going to probably have an impact on what assets you might want, what's more advantageous to you, and what that looks like. So, but the question for many people might be, well, what does community property division mean? Does it mean we just split it in half? And the answer to that is no. We are not what we would call a 50-50 state. States like California are 50-50 states, so that means they're a community property state. So all of the rules of community property I just breezed over there, they do apply, but it means no matter how long you're married, no matter what your incomes are, no matter what the story of your marriage is, it just gets split in half. We don't have that rule in Washington. So what does that mean? It means there's more to discuss. It means there's more to potentially fight about. It means that the details of your marriage matter, which is why gray divorce is in that, later in life, whether they're long-term or mid-term or even short-term marriages, have different consequences. Our standard for dividing a community property is what's called just and equitable. So supposedly that means whatever's fair. Well, I can tell you everybody has a different definition of what fair is. There are some guidelines to determine that, and factors, and there have been Washington cases on it. But the most important thing to know is, if you were married and someone stayed home and did a lot of the work at home and the other party is still working, this is another issue too. In a longer term marriage, people might be near retirement age or maybe at it, or you could also have a long-term marriage where the parties are barely 50 and you've been married for 25 years, but you're going to work for another 15. That creates another set of interesting consequences. But you are basically looking at the story of your marriage to determine who maybe is the more moneyed spouse and who's going to continue to earn income as opposed to the other party post-divorce. Usually the party that is the financially disadvantaged spouse in a lot of situations will take more of the community assets than the other party. And the reason why is because they're going to spend down their resources a lot faster than the person still working. And that usually applies if the parties are working. If the parties are not working or near retirement age in a long-term marriage, it's very normal to say, hey, we're going to be equalized. So we're going to divide everything, which makes it fairly simple once you realize what the assets are. And we're also going to look at who has how much separate property and see how we can get the parties equalized, because there's a general principle that the parties should be fairly equalized moving forward, especially at the end of their lives, working lives, I should say. So there is that. So it's common for the parties to divide the assets and perhaps one party to receive spousal maintenance from the other party if they are still working. And that brings me to the next issue, spousal maintenance. You may have heard spousal maintenance, spousal support, or alimony. They all mean the same thing. In Washington, we don't use the term alimony. We don't actually have a legal term called alimony, which is, you hear that on TV, you hear that in other states. We don't have that term. So spousal maintenance is the Washington term for alimony, also known as spousal support. In that kind of a situation, that basically means two types of support. Usually we're talking about post-divorce support from one party paid to the other party to provide, basics of living and everything else. So there is also temporary support, which is really important, especially in Washington, because in Washington, a case can take a while. Like I said before, it's a marathon, it's not a sprint. So it can take you a while to get to the end of your case. And during that time, you might be living separately. Most people are actually by then, and your divorce could go on a year or more. And if it does, one party needs to be paying temporary support to the other party. So that's something that's established early on in your case if you have a need for it. In some instances, the parties might be really amicable and they might just still be sharing joint accounts. And if that's working, that's fine. But a lot of the time that's not working. And if that's not working, or if it's just we need to establish a new normal, it's not uncommon to have temporary support, especially in a longer term or late term marriage. And I say late, I mean later in life. So that's completely normal. And people always want to know too, well, how much am I going to get? And spousal support or spousal maintenance, we don't have a statutory formula for that. We do for child support in Washington, and other states like California actually has like a formula for spousal maintenance. We don't have that. We have basic guidelines, and we have basic, not just guidelines, but I would say calculations that we do to determine what's appropriate support, but there's a lot of what we would call discretion. So if the court's going to make a decision, they can essentially make almost any decision that they want as long as it's somewhat reasonable. And you could go into 4 or 5 different courtrooms, get 4 or 5 different spousal maintenance rulings, and they would all somehow be right because the court's given a lot of discretion. So most people don't leave these decisions up to a court. They try to negotiate a resolution either through negotiation with attorneys or in a mediation, and come up with a spousal support that's somewhat reflective of what a court would do in what I would call a reasonable range of risk. So both parties know, hey, we're within this range and that's likely what would happen, so it makes sense to settle on it. Typical formulas for spousal support kind of don't apply as much. They do apply, but not as much in a longer term marriage as they do in a midterm or a short term. I'll go over briefly the 3 types of marriages as they relate to spousal maintenance, just so there's an understanding about that. One of those is a short-term marriage. Well, and this could happen because sometimes divorce patterns tend to repeat themselves, which sounds super negative, but it's super accurate, where if you're on your 2nd or 3rd marriage, and maybe you got married later in life, and you're getting divorced, it's not uncommon. If you got divorced before, the odds of getting divorced in a 2nd or 3rd marriage go up exponentially, kind of because you've been there before, you might not have kids binding you together, and these things happen. So if you're in a short-term marriage, which is, like I said, not uncommon to have people maybe in their 60s divorcing who have only been married 5 or 6 years, which happens, that's a short-term marriage. A short-term marriage in Washington is around 5 or 6 years. I would say probably 5, but it's not written in stone, to 0 years. And so in those, post-divorce maintenance is not super common because the goal of a court is to put the parties back in the situation that they started in. You still divide community property, but you're not looking to provide long-term support from one party to the other. That doesn't apply. A typical maintenance formula in a short-term marriage might be 4 years of marriage is 1 year of maintenance. So if you're married for 5 years, maybe you're paying like a year and plus, a little bit plus of maintenance. However, if the parties are financially similarly situated, you're probably not paying maintenance at all. Maintenance is not a given in a short-term marriage. Medium-term marriages which also happen in the gray divorce category. And they're actually the most common divorces are, 6, 7 years on up to around 20 plus years. Those are midterm. I mean, and there's longer midterm marriages and obviously much shorter ones. An 8-year marriage is different than a 20-year marriage, 22-year marriage. But you're looking there again at maintenance calculations. Anywhere from 3 years of maintenance to 4 years of maintenance is 1 year of marriage. So, and that's where we get into the specifics of your marriage and what the situation is. So if one party, 15-year marriage, one party stayed home and didn't work, whether they had kids or not, the other party really financially paid for everything by going to work, while the other person supported the household. That's, it depends on also too, what side you're on. One party's probably pushing for a 3-to-1 calculation. So maybe around 5 years of post-divorce maintenance. Other party's probably pushing for a 4-to-1 calculation to get it lower. Important thing to know is that in a gray divorce, this is where retirement age comes into play, because you could be getting divorced where both people are 65 or older and not working. If that's the case, maintenance is about a different thing. It's not about wages during the marriage. It's about looking at Social Security benefits. It's about looking at pension payouts. It's about looking at investment income and finding out if we can just equalize people that might not need to be maintenance, or if one party's benefits are a lot more than the others, the maintenance might be based on that to equalize them. But if it's a midterm marriage, you're probably not looking at equalization. You're probably looking at, a 3 or 4-to-1 calculation. If you're looking at a 25-year marriage or more and parties are retirement age, then we need to make sure the parties have equal resources in retirement. So length of marriage really has a bearing on spousal maintenance. That's an easy thing to say. I will also touch briefly on the last two that are issues for divorce in general. One is parenting plan. And like I said earlier, later in life marriages, a lot of the time you're not dealing with parenting issues because kids are gone, they're out of the house, or you might not have kids in common. But I will touch on it because people are also having children a lot later than they used to now. So you could have, and there are some people who just had children later in life, and that's just the way it was. And so you could have a couple that had, 2 children, late 30s and early 40s, and they're getting divorced in their mid 50s, and you still have kids at home. So there are issues with a parenting plan that might need to be addressed. Parenting plan is essentially a court order, but it's a plan. We don't use custody either. That's another term that's different in Washington. And if you joined my webinars before, you've heard me say that, where we don't use the term custody. There's no custody order, none of that. We use a residential schedule or parenting plan. We use friendlier terms that I think are actually more literal and easier for people to understand. So a parenting plan would decide where the kids are going to live, with who, on what schedule, what's going to happen for holidays, and who's going to make major decisions. So those things are all super important. I won't go too much into parenting plans, just because it's not always on point for a gray divorce, but it does come up. And so it's important to know you're going to need to decide that. I will say one other thing about a parenting plan is parties can deviate from a plan. So a lot of the time, if you're getting divorced later in life, and you might have teenage kids, and having teenage kids, you don't have to do every single thing that's on that sheet. If you guys get along and, the kids say, hey, I want to stay at mom's or dad's, or I want to deviate from this or that, parties can always make any agreements that they want. Your parenting plan is kind of your default if nothing's going right. So the parenting plan, if you have children, is required to be entered by the court. So that's super important to know. Last thing, and this does come up with college age kids even, is child support. Child support is applicable anytime you have a parenting plan, and sometimes even when you don't, if you're dealing with what we call post-secondary support. So let's talk about child support for a minute. It can apply, like I said, if you have kids, even if they're teenagers and they're living at home. And child support is different than the other things I talked about, which have a lot more gray area. Child support is based on the income of the parties, the age of the children, and the county you live in. So you could say I have a 15 and a 13-year-old, and I live in King County, and you put that in, and you put in what the income of each party is, and there's actually a formula that will tell us how much the child support should be after allowable retirement deductions and taxes and anything like that. So it's important for you to know that child support can be an issue, and it is a statutory formula. The other thing that's really important about child support, this usually applies most in gray divorce, is the proportional share in a child support worksheet and child support order. You will probably share proportionally if you have teenage kids and they're getting close to leaving the home in extracurricular activities, out-of-pocket expenses, non-covered copays, things like that. You will share those proportionally, and that's set forth in your child support order. So basically, and this can sound confusing and abstract without going over documents, but you could say, here's our child support number for these two kids. Here's our number. And then you would say the person who has the kids more residentially pays, receives the percentage of that child support number from the other parent every month. And that's what we call the child support transfer payment. And I know it sounds really abstract and confusing, but basically party who has the kids less pays their part of the number to party who has the kids more. And that percentage, you split the child support number based on what percentage of it is for each person's income. Those percentages are what guide, unless you make an agreement otherwise, which you can do in a child support order, but those percentages generally guide extracurricular activities, summer school, driver's ed, all of those things that come up when you have teenagers, and that's really important. Also work-related childcare, but that's far less of an issue in a gray divorce. So it's really nice not to have to deal with that because that's astronomically expensive, actually. So that's something. The last thing I will touch on that really does seem to apply in these cases is post-secondary educational support for your children. You may have set up 529 plans during the marriage. You may have a GET plan. There could be any number of things that you might have done, or a savings account, or maybe you didn't do anything because you just figured we'll deal with it when the time comes. And here you are, and now you are separated and you don't know who's going to help a child that's already in college or a child that's going to college in the next year or two pay for college. Post-secondary support refers to support after high school. And so, it doesn't just apply to college, it can apply to trade schools or any number of things. So that's something that will generally need to be determined, and it will depend on the assets that you have from during the marriage. It will depend on what you want to agree to post-divorce, but it's something that comes up. So college planning is something that comes up if you have teenage kids. So those are kind of the big four issues. What I will do before I go on is, Melissa, do we have any questions that I need to answer?
So I think I forgot to say earlier, but if you do have questions, please pop those into the Q&A or the chat. You can send them to me and we will make sure that they get addressed and answered. I do have a couple of pre-submitted questions that I'll ask, but I just want to tell our participants here, if you do have any questions that you'd like to have answered, please go ahead and put that either in the Q&A or the chat. I can check both places and make sure that we get those answered for you.
Sure. What are the pre-submitted ones? I'll deal with those before I keep talking.
Yeah, hold on really quick. I'm gonna grab one for you here. Okay, this question, it says, is there anything specific I should be considering in my divorce if we have adult children? It's obviously different than if kids were younger, but wondering if there's any considerations there.
Yeah, I would say yes. I would say one is something I hit on a little earlier, which is the communication piece. You should talk with your spouse about how you're going to tell the children and when you're going to tell them or who's going to tell them. It's great if you could both tell them, but I know that it can really damage adult-child relationships with one parent or the other if they feel like a parent's keeping it from them, or if both parents were keeping it from them. So how you're going to tell them and when and what that messaging is going to look like and making sure it's consistent is important. Also, this applies almost more with adult children than you would think, but not talking bad about the other parent and trying to blame it on someone. I mean, you can tell them, they're not kids, so you can tell them what you want to tell them, but they'll figure it out on their own generally, who they want to support, or if they can support both of you. But really the messaging is super important. And you might have grandchildren too, and that's something that their parents can decide how to communicate to them. It's generally not necessary for you to talk to your grandkids about your divorce. Leave it up to their parents, because I've had that happen before, where grandparents told kids were upset, and then adult children were upset that they weren't the ones to deliver the message. So anyway, those are basic things. Also too, inheritance is another issue. One thing you really need to think about in a later in life divorce is having your estate plan redone. I do a lot of estate plans for people who go through late in life transitions, and you might kind of go, well, I was leaving my entire estate to my spouse, figuring that then one of us would die and the other one would leave everything to the kids. Well, that's not the case anymore. You're going to want to update it, and you're probably going to want to divide your estate amongst your children, or maybe you have other family members. I don't know, but it's important for you to, think about what you're leaving to whom, and maybe even involving your children in your estate planning conversation so they know that you're doing one, because adult children will really appreciate knowing that you've made those plans. As well, and doing a healthcare directive and a durable power of attorney for later in life. I can't tell you enough how important that is, especially if you have multiple adult age children and you won't have a spouse making those decisions for you. You're going to want to figure out who is going to make those decisions for you and who is going to be the personal representative for your estate. All of those things will need to happen, especially if you have multiple adult children. So that's a
Yeah,
great question.
it is. Just to piggyback on that a little bit, Michelle was talking about communication with your adult children, and how messaging and trying to unite as much as possible there. Just wanted to also mention that I think it's important to kind of be a little bit careful about how you use your adult children in terms of your own emotional support. Not to say, you might have a great relationship with your adult children and they can be a source of support, but if you're trying to also help them maintain a relationship with their other parent, it might be important to make sure that they're not your sole support, and then that you're not, relying too much on them. That could be really burdensome for adult children.
Right.
And we might sometimes forget that they are still our children, and they're also our soon to be former spouse's children. And so just really wanted to sort of put in a word of caution there.
Definitely. No, definitely. Yeah.
Yeah.
Anything else that was pre-submitted,
Yeah,
Melissa?
there's now several questions in the chat and
Okay.
Q&A as well, but let me ask the other pre-submitted question. You
Sure.
kind of touched on this, you did touch on this quite a bit earlier, but just wondering if there's anything else you want to add. I'm worried about financially supporting myself when he's always been the primary breadwinner.
Yeah.
How do I ensure that we split our assets evenly?
You get an attorney because I have to tell you, I represent people that are the primary breadwinner and I represent people that are not. And it's just a thing where people are the primary breadwinner have this, like, not everybody, but a lot of the time they'll have this innate sense of, it's more fair for me to keep more because I earned it. And that's absolutely not accurate, not true. And I always tell my clients that are the financially disadvantaged spouse, like what we would call you in the divorce, because you weren't the primary breadwinner, you have more power in the divorce process than the person who's going to divide assets and pay you maintenance. It's just, you're going to get money. It's just a question of how much and at what stage, and you want to plan for that. So, if you're scared, thinking we've been in a long-term marriage, he always paid for everything because he worked and I managed everything else, and those were our roles. You don't have to be scared because the law in Washington recognizes that, and that's why we have spousal maintenance, and that's why we have disproportionate property divisions in midterm marriages where somebody might get a larger percentage of the community because they're not going to recover financially from the divorce as fast. But if you just try to negotiate with your spouse, they're not going to necessarily know the law, and they're not going to be looking out for your best interest. They're going to be looking out for theirs or what they might think is fair. So I recommend that you talk to an attorney who knows about family law. It doesn't have to be me, but anybody that you want to talk to get some information about what would happen typically in a situation like yours. I mean, I'm not going to be able to go through and give legal advice on people's situations here, but I've kind of given you an idea that you want to look at the specific facts of your case because that's going to help guide you. And you want to get that temporary support in place that I talked about earlier if you don't have access to resources right now. A lot of the time, some parties will a financially advantaged spouse, like if they come talk to me or another attorney, the attorney will say, look, you're gonna have to share your resources, and they wrap their minds around that pretty quickly once they've heard it from an attorney. And so they don't try to segregate the funds. You guys can keep spending out of the joint account while the divorce is going on and a settlement is reached. That does happen too. So either side of the coin, whether you're the breadwinner or whether you're the person who wasn't the breadwinner, you have certain realities to come to grips with. One thing I do want to say about that is that your assets may not, your community assets may not be enough for both parties to maintain the standard of living that you're used to. And if that's the case, I mean, it's obviously going to cost you more. And this is why a lot of people wait till later in life, which I'm not saying is a good thing at all, but people do sometimes just hold on for financial reasons. And, it costs more for two people to live separately, obviously, than it does for under one household. So standards of living sometimes have to change if there's not money to maintain the same standard for both. But it shouldn't be in a long-term marriage anyway, that one party is living in the family home and the other party is barely making it in a studio. I mean, that's not equitable and that won't happen. So you don't have to be worried about that. You just need to get help to guide you through it.
So I don't know if you want to jump into other content, or I do have several questions.
I want to make sure, I mean, it's already past 1:30, so I want to make sure I'll take like a few questions, and then I'll just go through a little bit more. But I think it's important to get their questions answered if we can.
Definitely. Okay, this question asks, in a 4-year marriage where the woman gave up profession, home, and moved to another city to marry, Does the court take into consideration the loss of the spouse who left their life behind, retirement, loss, Social Security, etc.? Apparently husband now saying that there is no community property.
Well, if you're married for 4 years, it's definitely community property. The husband might not want to say there's community property, but there's, unless you have nothing from during those 4 years, nobody contributed to anything during those 4 years, and you spent every dime you guys had, you have community property. But in a 4-year marriage, court's going to be more concerned with putting you back where you started. So in some ways, like if you left a state and did all of these things, court's going to kind of be like, okay, I mean, they'll recognize a little bit that if you made major concessions, but a loss in Social Security and income isn't, the court's not going to see that as a huge thing for 4 years. They might think, okay, you need to make sure you have funds to get back if you want to move back to where you came from, or, dividing the property equally. But in a 4-year marriage, nobody's going to be, giving you maintenance based on that. I mean, maybe you get a little bit just leaving the marriage. So if there's a big imbalance, but it's not a long-term marriage. So, the facts though do matter. And if you gave up a job and moved and did a bunch of stuff, I mean, the court's going to want to make sure that you get your share of whatever the community is, and maybe a little maintenance to, leave you to exit the marriage if you need that.
This question says, if I was married 9 years, almost 10 years,
midterm marriage,
and we have 2 children, was working, and now I'm on short-term disability because of a car accident, what happens there? I'm not sure.
A lot of things could happen there. I would think, you're going to have a parenting plan. If you're the primary parent, you're going to get child support. And depending on what the financial situation is, if you're on disability, your income is not what it was, you're just getting disability income. So then it's a question of what your spouse's situation is. So you're probably looking at dealing with potentially all 4 issues in that case: debts and assets, parenting plan, child support, and spousal maintenance. So it sounds like you have a lot going on. But, careful planning and understanding what the implications of your situation are very important. Great question.
Okay, and what things should I do or take note of before starting divorce to maximize chance of custody of a toddler?
Okay, well, you're probably not in a great divorce. Maybe you are, but anyway, that's that could be a lot of different things. So when you're talking about custody too, I'll talk about that. I don't talk about that usually a lot in these webinars because it doesn't apply to most people, but I'll touch on it briefly. In determining a parenting plan, the court's going to look at there's no presumption for the mother in Washington. There's no presumption for dad. There's a presumption for what's in the best interest of the children. And there are a number of factors the court will consider in determining that. So it used to just be that, one parent did most of the parenting, other parents every other weekend, and maybe a midweek dinner visit. And then it moved more to every other weekend and a midweek overnight. And now it's even moved more to, unless there's a reason not to, parties have a real shot at a 50-50 plan, even if one parent maybe didn't do a lot of the parenting before, because there is a lot more recognition that both parents post-divorce, the relationship's going to be different because roles change and they should have every opportunity to parent that the other one did. So that is completely not uncommon. If either party has what we call limiting factors, so significant mental health issues where there's a nexus with parenting, drug and alcohol issues, abuse where there's a nexus with the parenting, or domestic violence finding, those can be reasons to limit parenting time. If you're looking at custody, we don't really use that term, but you might be talking about who has the child how much. There's 2 kinds of what we would call custody in Washington: physical and legal. Physical is your residential schedule, who has the kids when, and legal is if you're both legally able to make decisions for the child and get information. You're both legal parents, so you both have legal custody at all times, unless you've given up your rights. You both have some physical custody under most fact scenarios, unless one party is so significantly restricted because of domestic violence or abuse that they don't see the child or children. But if you're thinking about, hey, I want to figure out first what kind of a parenting plan you want for your toddler, think about what is realistic with the schedule. I will say a lot of times with young children, it's very hard for them to be away from one parent for a long period of time. So whereas, I could do a whole hour on parenting plans, I could do 3 hours on parenting plans, but whereas one party, when the kids are older, they might do week on, week off. Like teenage, I should touch on that briefly. Teenage kids, that's really common, especially in a great divorce situation where maybe one, they just go from one house 1 week to the other. They don't have a problem with spending a lot of time away from either parent. They probably want to because they're teenagers. But when your kids are young, like toddler age, it's recognized that that's not common. So a 2-2-3 plan is pretty common: 2 days with one parent, 2 days with the other, and then a rotating 3-day weekend that flips between the parents. 3-3-4 plans. There's a lot of different plans. So if you want a 50-50 plan, that's something you want to start planning for and looking at how to show that that's in the best interest of the child. If the parties don't live close to each other, that can be a reason not to have equal parenting time. If you think there are issues with the other parent where they're not a suitable parent, they're a danger to the child, then you're probably looking at trying to be a primary parent, and you would want to look at how to best position yourself. There are a lot of things like that. So hopefully some of that's helpful, but I would talk with an attorney and figure out what you want and how to best align yourself to reach those goals. Anything else, or should I
I
keep
do
going?
have one more question here. Is there an
Sure.
advantage or a disadvantage to being the initiator of the divorce action as opposed to the responder?
No, it doesn't matter. When I say that, like, Washington is a no-fault state, so if someone petitions for divorce, they don't have to prove fault. If someone's responding to the divorce, they can, whoever files is basically just you're filing a petition for divorce, saying in general what I would call a vanilla petition, asking for decisions to be made later, because you don't really know what all there is to put in a petition. We don't usually do what's called a specific petition saying this is everything I want. If you do, I actually think that's foolish, because you might not know, and then you have to amend it later if you want to change what you're asking for. So if you are filing or responding, it really doesn't matter. The court doesn't care and nobody cares. But there is one instance where I do think it is advantageous to be the party filing, and that is if you're seeking temporary relief. So that could be temporary spousal support, temporary child support, or a temporary parenting plan. If you need temporary relief, either party can file for temporary relief at any time. But if you're the party that's filing for the divorce, it's not uncommon to file for what we call temporary orders and set a hearing for that at the same time. If you do that, then you got to do it first, because the other party might not have known it was coming, or you just did it all together. If the other party files the divorce and nobody files a motion, you could file a motion first at any time. It's more advantageous to be the party filing, and the reason why is because you get to ask for what you want, the other party gets to respond to it, and then you get to respond to what the other party said. So you get 2 bites at the apple instead of 1. So I do think if you file for divorce and you're going to seek temporary relief, that's an advantage, but otherwise it really doesn't matter at all. So I hope that's helpful.
That's great.
Yeah.
That's all the questions that we have so far. So if you have others,
Cool.
you wanna
Yeah, we have a little time too. So what I think I'll do is talk about things to consider. Social Security is something that comes up a lot in a gray divorce. So if you're going through a gray divorce, you definitely need to consider the effect this will have on your Social Security benefits. A potential income stream through Social Security should be considered at the time of divorce. You can easily go, you might have already done this, but you get a statement every year that you can go online and review what your benefits will be depending on how old you are. You can see, wage history there. It's really important, and it would be part of any later in life divorce to determine what people's benefits are going to be. You should also understand the consequences of remarriage on Social Security benefits. So those are things that you're going to want to know. The lesser earning spouse too, this is something a lot of people don't know, may qualify for spousal Social Security benefits. So if you're married for 10 years or more, I actually have also had parties where they've stayed married just till 10 years or not finalized until then to take advantage of this. But let's say that one party didn't work during the marriage very much, or let's say one party just made considerably less money. So your Social Security benefits are going to be different, right? Well, the court can't divide Social Security benefits at trial. So we're not talking about like fighting about a division, but you might qualify based on your spouse's earning history. So it's common when one spouse makes a lot less than the other. What typically happens in that situation is you automatically, if you were married for 10 years or more, and you're married for at least 10 years before divorcing, and you're at least 62 years old when you start drawing, and you remain unmarried after the divorce, you qualify. If you get remarried, you don't qualify for this rule. And so if your former spouse is entitled to Social Security or disability benefits, you are entitled to either half of your spouse's benefit, and it doesn't reduce your spouse's benefit. This is one spot where the government is like surprisingly generous. Your spouse gets to take their full benefit. You get the value of half of it if that's more than what your benefit would be. And a lot of the time it is, because, let's say a spouse has a $3,500 a month benefit, and half of that is $1,750 or whatever, then that's more than $1,000 a month or $800 a month that you're going to get. You're going to get that. So that's super important to know. But if you get remarried, you don't get that. Like, that's out the door. So something to think about. And those actual payments are a payment of that person's benefit, and it's based on their former spouse's employment record. So that's actually really important. Also, too, survivor benefits are important to know about. So if one of the former spouses dies, the other may be entitled to survivor benefits if the marriage lasted longer than 10 years and you're currently unmarried and 60 or older. So, or 50 if you're disabled. But if you get remarried, you don't get the survivor benefit. Or if the spouse gets remarried, well, their current spouse is going to get it. So that's something to know. Medicare too, you might qualify for Medicare under your former spouse's work record. If you're eligible for Social Security benefits under the same, you generally have to be 65 or older to qualify, but disabled divorced widows can qualify, widows under 65, disabled children. So you might qualify for Medicare based on that if you've been married and you qualify for Social Security. So that's something really important to know. And the good thing to know too is you don't have to wait for your former spouse. Like if you're going through a later in life divorce, you don't have to wait for them to draw on benefits. You just have to be generally 65 or to qualify. You can't draw early at 62. But let's say your former spouse is still working, you can, or you're younger or whatever, or older, you can draw at 65. So that's an important benefit to know. A lot of people don't know that, but it's not uncommon later in life marriages now. So if your benefits stop if you get remarried. So that's important to know. I've had so many people come to me and say, oh, I didn't know that. And maybe they got divorced, a long time ago. That's something you want to consider. You might want to do another kind of memorialization of a new relationship. There are domestic partnerships in Washington, which basically nobody gets now because we have marriage equality and everyone can get married. It used to be mainly LGBTQ focused, but now those domestic partnerships really only apply to people who are 62 or older if they don't want to lose benefits. They can enter into a domestic partnership to get certain rights with a new partner later in life post 62 and not face losing benefits. So that's something to know about that's more complex that you should keep in mind. Insurance is another big piece too that comes up in gray divorce. Health and life insurance always both need to be addressed. So it's super important for you to think about that. Couples that divorce after 50, but before qualifying for Medicare, you need to consider the cost of your insurance in exiting the marriage. That might be part of spousal maintenance. It might be part of your property division, but you're going to need, maybe you're going to be on COBRA if the spouse is still working, or maybe you're going to get your own plan because like Melissa mentioned earlier, divorce is a life-changing event, both emotionally and legally. So you can qualify for new policy, but the cost of insurance is important. Or if you're going to be paying, how much that's going to be for the other party to sustain benefits for a period of time. So life insurance is typically considered with a spousal maintenance award as a means of providing security that the maintenance will be paid even if someone dies. So what I mean by that is this. Let's say Party A is paying Party B maintenance for 8 years until they get to retirement. So Party A will likely have to take out, and this would be in your divorce paperwork, a spousal maintenance, an insurance policy on the spousal maintenance that benefits Party B and declines as the award declines, but covers the amount of the social maintenance. I'm sorry, the social spousal maintenance. Can talk today. That way, if you're later in life and someone dies and there's a healthcare issue, you don't not get your claim, you don't not get your maintenance, and also that person's estate, you either have a claim on the estate or you have insurance, and most people want to guarantee that by insurance. So, your attorney should help you make sure that you have that provision in there, but that's something you definitely want to take into consideration. Melissa, do you have anything else? Because I can move on to another topic, but I'm probably going to run out of time if I move on to another topic. So let me know if we have anything else. I'd rather see that.
Even if you're divorced the second time and were married over 10 years in the first marriage, could you collect on the first husband's Social Security?
Yeah, if you were married a second time, the benefit stops. But then let's say you get divorced, you qualify again for the first person. So let's say you were married like 15 years, then you get married and it only lasts 4 or 5 years, and then you're divorced again, you still qualify for that first person's Social Security. So that's actually a good thing. And a lot of people don't know that.
That's a good question.
Yeah, it's a great question, actually. Thank you. Yeah. For always forget to mention that.
Yeah. I don't have any other questions right now, but we don't have that much time left either. So it might not make sense. I don't know if you want to roll into another topic.
I think I won't. I'll just go over kind of the things to consider. Social Security, which I got into a little bit, income and spousal support, which I got into a little bit, division of assets, we talked about that quite a bit. Insurance, I touched on that. Competency is something that, doesn't come up a lot in divorces other than gray divorce, but when people are older, I actually have had this come up too. Maybe one party doesn't have the capacity to actually enter into the divorce if there are cognitive issues. That's something that you need to address with an attorney. That'll require review of medical documentation, and you might actually have to have what we call a guardian ad litem appointed to act on behalf of an incapacitated spouse. You still can get a divorce. I've actually done these divorces, and it still can happen, but there's special considerations, and that sometimes happens in what we would call a gray divorce that wouldn't happen in other cases. Other long-term considerations, adult children, we talked a little bit about that. Long-term care, we didn't get a chance to talk about that. Washington also has this new requirement for long-term care, so a lot to talk about there. We could do a whole other session on that. And then estate planning, I did touch a little bit on that. You definitely want to update your estate plan if you are looking at a divorce later in life, regardless of how long you've been married. So I hope this was helpful. Thanks for joining us today. It was nice to get your questions. You guys asked really great questions. And I think just the fact that you're here and trying to get more information in a situation that's really difficult is a testament to you. A lot of people choose to just avoid talking about these things because it's easier, and it doesn't mean that the issues go away. So getting more information is the first step. Getting support, whether it's emotional, legal, family support, is the second, and then gathering resources and moving forward when you're ready is the third. So I hope that helps. Take care.
Absolutely. And here's some contact information. If you're interested in getting in touch or having a consultation, please do reach out. And we do hold webinars. We try to hold them once a month. We also have a meetup group on the Meetup app, and we do those once a month as well, where you can gather some more information and get some resources.
Yeah, thanks a lot. I hope you guys have a great day.
For more information. Okay. All right.
Take
Take
care.
care, everybody. Bye-bye.
Bye.